Good morning. Welcome to Worklaw's webinar. On my left is Alan Rycroft. I'm Bruce Robertson, and we're going to take you through in the next hour and a half to 2 hours. We're going to cover two subjects. The first is complying with the new Harassment Code that was published in March of this year and has some important implications, which we're going to cover. And then secondly, we're going to change tack completely and discuss evidence, a very practical hands-on session on compiling evidence, effective evidence to support charges in a disciplinary inquiry. Please use the question and answer function at the bottom of your screens. Ask any questions that you want to ask, and we'll obviously do our best to answer those at the end of our presentation. So we'll hold questions and deal with them at the end. Can we also say that we are going to move quite fast? We're unsure how long it's going to take us to cover all the content, but we have written a paper covering both these subjects, and that paper will be available on Worklaw within the next week. We'll also put up a copy of our PowerPoint presentation as well on Worklaw. So you'll have access to both of those, and the paper that we've written is probably more comprehensive than what we're going to cover live in this webinar. Anything I've missed out, Alan?
I don't think so. That's pretty
all right, let's jump straight in. Firstly, on the new Code of Good Practice, Alan, most organizations have had sexual harassment codes for a long time. Why the new code covering harassment?
Well, in 1994, South Africa rejoined the ILO, the International Labour Organization based in Geneva. It's an organization that exists to standardize working conditions across the world. And so when South Africa joined the ILO again, it was obliged to consider ratifying various bits of ILO conventions. And it did ratify the ILO Convention on Violence and Harassment Convention of 2019. When you ratify a convention of the ILO, you're obliged as a country to incorporate it in your own national legislation. So the code on harassment is South Africa's complying with its obligation.
Okay. And just to remind us of the importance of a code, why are they important?
A code, in terms of Section 203 of the Labour Relations Act, any decision maker, usually an arbitrator, but also a disciplinary chairperson, is obliged to take into account a code, which is, it could be the Code of Good Practice on dismissal or operational requirements dismissals. You are obliged to refer to the code, and that's meant to standardize labour decision making.
And we'll see later in our when we deal with the issues how important this is. When, for example, when we look later at the employer liability under Section 60, but we'll come back to that and deal with that later. Just briefly, the types of harassment which are then covered in this code, if you can give me a sec, I'm going to call up a PowerPoint. The types of harassment covered?
Well, as you said at the beginning, Bruce, the sexual harassment, which is being covered in a separate code, is going to be forwarded to the new Harassment Code. And you'll find that the wording and the concepts are identical.
And this new code supersedes that previous sexual harassment code.
And so if you're familiar with the old sexual harassment code, you will recognize much of the new code.
Yeah. And I mean, those employers out there who have an existing sexual harassment code, we're going to ask you to apply your minds to how you're going to adapt that and broaden that to cover other forms of harassment.
Yeah. And secondly, racial, ethnic, social origin harassment. This is a new idea to put into a harassment code, but what it does do, it brings together all the cases that have held over since 1994 what is racial harassment, and it's a very useful thing to have in a code and a workplace policy.
Okay, and then thirdly,
something which is really completely new is the idea of bullying or just general harassment, we won't have time to go into the contents of the code on bullying and racial harassment. And so we really urge you to read it yourself. It's already up on Worklaw.
The code, yeah, the code's up on Worklaw. And just a bit more about what is harassment? What constitutes harassment?
Well, I think you've got to understand that it's we all use the phrase when our children are worrying us, we say, I feel so harassed. It's not that kind of concept of just like being sort of bothered. It's defined in the code as unwanted conduct, which itself is a complex area. How do you know something's unwanted? I might tease you in an inappropriate way.
As you do often.
That's been known to happen. And then if you said to me, actually, I was really offended by that.
Which I normally am.
Then I know it's unwanted.
Yes.
So, but I mean, there is the concept of you should have known.
Yeah. You ought to have known.
Ought to have known, which is complex, but it's unwanted conduct.
Because that ought to have known, there's both a subjective and an objective element to that.
Correct. Yeah.
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 Okay, so it's unwanted conduct. That's.
And then it impairs dignity, which is dignity is not an easy concept to pin down, but it's about our self-worth. It's about our sense of personhood. We all know when our dignity is affected. It wounds us deeply.
Yeah.
We can feel it. More difficult to describe it, but the word dignity is what's required to have your dignity impaired. And then secondly, this unwanted conduct must create a hostile or intimidating work environment. You can see what the code is aiming at. They're trying to aim at workplaces where an employee is not scared to be there, is not afraid of being bullied or being...
Doesn't wake up with a knot in his or her stomach every morning before going to work.
That's right. So that's the aim.
Yeah.
But the third one is the most significant. It's only harassment if the harassment is related to one of the discrimination grounds under Section 6(1) of the EEA, the Employment Equity Act. Now, you remember that's a list of prohibited grounds on which you cannot discriminate: gender, sex, age, disability, social origins, race. Yeah. There's a long list, pregnancy, and so on. And so I think you need to say this straight off at this point of the webinar, is that not everything that happens in the workplace will fall into this legal definition of harassment. You might have a person who's just a difficult person, and the harassment is not related to that person's race or gender or age or disability. This person's just a difficult person. That person will have difficulty to bring the teasing, the comments, whatever that person's receiving into this definition.
Yeah, it's a bit of a hobby horse of ours, those of you who've read lots of previous work law newsletters and so on. We, for example, have a similar concern about the unfair discrimination section of the Employment Equity Act, where and the cases have said it's not arbitrariness is not in itself enough. It's got to be linked to one of the grounds under Section 6(1) or those types of grounds. And so it's a concern of ours, and we'll come back to this later with problems with applying the code. But that point needs to be noted that this is a definition of harassment under the code. So all three elements have to be present. They are and.
Yeah,
that's correct.
That's right.
Okay. Just some examples that the code gives of what is harassment.
Yeah, well, in fact, I should say at this point, one of the grounds on which the code has been criticized is that it departs from principle and gives too many examples, which are a bit scary, but nevertheless they are helpful. So look at these ones. Slandering an employee, spreading rumors. Just think about it for a moment. Workplaces love scandal, and we can all willingly or unwillingly, we often unwittingly, pass something on which really is hurtful.
Yeah.
And that's one of the targets. Humiliating or insulting an employee, withholding work-related information, in other words, sabotaging a person's career. Well, that's actually spelled out in the next one here. Being excluded from activities and being boycotted as a person. It happens, sometimes people are difficult. Intolerance of employees' personal circumstances. Could be disability. It could be a whole host of things. Surveillance without the employee's knowledge. Demotion without justification. Abuse of the disciplinary proceedings. And pressurizing an employee to resign. I want to just make one observation at this point, Bruce. If you look at a number of those, some of those things can play part in normal and management practice. For example, surveillance without the employee's knowledge. There's been a big bit of media controversy about employers keeping a tabs on what workers working remotely are doing. You see, now is that legitimate management surveillance or not? So a lot of these cross over into legitimate management practices.
Do you want to comment also some of the more emotive aspects that have been commented on in the media, to be given as examples?
Yeah, in fact, the media picked up on one particular paragraph, which where the code says that passive aggressive or covert harassment may include negative gossip, negative joking at someone's expense, sarcasm, condescending eye contact, facial expression or gestures, mimicking to ridicule, and so on. Now, I'm a person who teases a lot in my family, and I raise my eyebrows, and you know how easy it is.
You have large eyebrows.
I do, but it's only, it's really easy behind one's back, looking at somebody else to go, like that.
Yeah.
That I think this is a warning bell to us that we've got to check our normal way of conducting ourselves in the workplace.
Yeah, but they still have to link back on that previous slide to the 3 elements of harassment.
Correct.
So it's got to be linked then to one of the grounds under that section 6.1 of the Employment Equity Act.
Correct. Yeah.
Okay. Let's get real and practical, and let's look at the code practically and look at what employers need to do to implement the code. And let's begin by saying the code in 5 sentences, that what an employer must do.
Employers must have a harassment policy. I'll explain later why that becomes really important. You can't blink on this one.
So a sexual harassment policy in itself is not enough.
No, you've got to have a harassment policy. And well, should I spell out why? But because an employer's liability for compensation will be linked to whether it has a harassment policy or not.
Yeah.
So basically, this is not something you can put on the back burner. Employers must get going today.
Yeah.
Yeah.
So, I mean, all the way through this presentation, we're going to be saying that there are really 2 main reasons why employers need to take this code seriously. Firstly, it's good for human resource practice, and it just creates the kind of working environment which we think we should have in the workplace. So it's good HR. And secondly, we'll be saying to you that there are significant legal reasons why you have to comply. In a sense, this is a form of risk management to comply with what we say.
Secondly, employers must take proactive steps to prevent harassment. That's what we're going to talk about it more closely now. Thirdly, to create a respectful working environment. Fourthly, to have clear procedures to resolve disputes. And then fifthly, please don't note that the duty not to harass applies to employers, to employees themselves, and unions.
Okay, so the duty to not harass applies to unions as well. It's quite an interesting point, because when we look at an employer's liability under section 60, and we'll come on to that in more detail later, but in theory, it's possible then for a union to have harassed its members, your employees, during a strike, for not taking part in the strike, having victimized them perhaps, and because you, the employer, haven't taken enough action, you might end up being liable for this harassment under section 60.
Yeah, I can see that to avoid liability, employers will need to contact the unions and say that we know that you are harassing non-strikers. This must stop. But I don't think you're going to be listening to.
We'll come on to that later. So that's in summary what we think an employer should do to comply with the code. Let's go into more detail under each of the 4 headings and see what specifically an employer should do.
Well, the first thing in developing a harassment policy, the code itself says that it invites employers to use the code as the main guide to capture the general definition of harassment, sexual harassment, racial harassment, and so on. So that's the first thing, to use the code in the development of the policy. Then rather unusually, the code says that the policy must contain about 6 statements in section 9, paragraph 9.4 of the code.
You want to give us some examples?
These are very generalized statements. So, for example, harassment, including acts of violence, will not be tolerated in the workplace. Grievances about harassment will be investigated and handled in a confidential manner. Very bland statements themselves, and probably would be scattered throughout an employer's policy.
But the code is saying you must include it.
That must be included somewhere. Yeah.
Okay.
Then a code, the policy must include informal and formal procedures. Now, for those of you who followed the sexual harassment code for your own internal sexual harassment policies, you'll know about these informal and formal procedures.
Yeah, they will come on to this in more detail later.
And there should be, the policy should outline counseling and support programs. It's been referred to in cases that an employer did nothing after a person was harassed, and that counted against the employer. Now the code is making this an explicit aspect of harassment. So moving on to what steps we should take, proactive steps to prevent harassment. This is once you've got a policy in place. Something which Bruce and I have been talking about is this one. Employers have got to conduct a harassment risk assessment. We've talked about how it could be done. We think that at the very least, departmental heads or managers should receive a questionnaire asking about what acts of harassment have taken place in the last 2 years and what are the likely, where the dangers are. Something where an audit is done. The failure to do this risk assessment will impact on compensation later on.
Yeah.
If the employer is found liable for harassment in the workplace.
Drawing from your experiences of conducting risk assessments for COVID, think about what the potential hotspots could be in your work environment. If you're a mine, for example, and you've got men and women employees working underground, and they go down a shaft in a lift, tightly packed in a very confined space, all bumping into each other, it seems to me that that's a perfect example where some form of harassment may take place. And maybe, maybe there's the possibility of having separate lifts for men and for women. So you eliminate that. In your risk assessment, you might pick up that as one of the hotspots, or there's a particular department in which complaints over the last 5 years, they've all emanated from the paint shop at the motor manufacturer, and maybe that department needs some particular care and attention. So, each workplace is going to be different, but you're going to have to conduct, in order to comply with the code, conduct this risk assessment.
Yeah.
Okay.
The second step that employers must take is to communicate the policy, effectively communicate is the word used in the code, the contents of the policy to all employees. Now, this is more, I think, than a notice on the notice board. This is a very deliberate part of worker education.
And is it good enough to do it once? Once you've communicated the policy, have you ticked that box?
I think for new employees, it must be part of induction. But I think that every year, the general manager needs to issue a reminder.
So keep this in people's mind. That it's an issue that needs to be addressed on an ongoing basis.
Yeah. Now, this is more specific. The code requires management to be educated about the policy and also how to handle harassment allegations. The failure to handle a harassment allegation appropriately will count against the employer. And if this is about risk assessment, this is an area where there is risk.
And in the one case that we will talk about later, which involved, compared to other cases, fairly minor forms of harassment, but the manager in question, in dealing with the concern or complaint, if I'm correct, said to the person who's been harassed, well, it isn't like you're being raped, which was taken note of by
the judge.
Was that the Labour Court one.
Yeah.
Yeah, and that was certainly part of the reasons why the compensation was awarded in that case under Section 6.
Also, another obligation under management education is that what's counting against employers in the cases is if they delay acting on complaints.
Yeah.
So that part of management education is act promptly.
Yeah, and you can decide for yourselves. I mean, do you have a complaints officer or someone in each region who's appointed, who's had particular training and has the skills and know-how in how to handle these complicated issues if they arise?
Now, this repeats the point made in the previous hearing, but the obligation is to make available counselling, treatment, care, and support of a person who's been harassed. Obviously, it's going to vary, and this might only apply to really severe, traumatized people. And in fact, the code says that employers should consider, doesn't say they must, but should consider paying for this counselling if necessary. If there isn't an in-house person, if the organisation isn't large enough. What the code does is make explicit an obligation to follow up on the effect of the harassment.
Yeah. All right, so that was step 2. Step 3, creating a respectful working environment.
Well, this is where it gets difficult, I think, because
how do you do this?
It's trying to often. Some workplaces are toxic, and it's how do you bring about a complete new way of conducting oneself? It's going to be very difficult for some very masculine, macho type of workplaces to really take on board that certain behaviours have got to stop. I think the first thing is really beyond communicating a policy. Leadership has got to develop a respectful organizational culture. It starts in the way meetings are conducted. It flows through on the way how complaints are lodged and how people are spoken to, and swearing and so on has got to be dealt with. And as Bruce has put here, live the values embedded in the code. It seems a bit new agey, but it's exactly what is the code requires to management and others to sort of live those values, and then apply the policy. I think this whole policy could die unless the employers are seen to be enforcing it, and that often then involves the discipline procedures. I think that's the way that I think workers learn very quickly that management will not tolerate harassment, and that's the way I think you reinforce that harassment-free working environment is the norm.
All right, and then one other point there, which we've got there, which I think is important, having ongoing awareness training programs. This is not just a one-off.
Correct. I mean, this is there's got to be an education budget here.
Yeah.
The fourth stage is to have clear procedures to resolve disputes. The first of these, it's even before you get to the procedures, to have clear harassment reporting guidelines so people know who to speak to. And so that's something which is, I think, more easy to put on a notice board. If you have a
and this would normally be a person outside of line management.
I think so.
Someone,
as you said just now, who's possibly been trained. And then, as you said before, make available counselling and support programs. And then, just like in the standards or in the sexual harassment code, it's recommended that you consider informal mediatory procedures.
What would the purpose of these be?
Because very often it might be a minor form. For example, the example I gave earlier, I might crack a rather off-color joke to you. If a person came to me and said, "Alan, do you know that you really caused offence?" I'd say, "Really? I'm sorry, it won't happen again." That can happen in 15 seconds. So these informal mediatory procedures are first prize if it restores relationships. And in fact, the case we're going to talk about, the Checkers case just now, it might later emerge that the woman who had been harassed would have accepted an apology.
Yeah.
And it ended up, all the litigation all the way up to the labour courts. So there are cases, Bruce, when the person harassed might say, I just want to have an informal procedure, where the employer might say, no, actually, we are going to insist on a disciplinary procedure.
Yeah, I mean, there might, in the same, I suppose a comparison you can make is two employees have a fight at work, and they pile into each other, but they sort it out, they apologize to each other, they sort out their differences, and they ask the employer not to take it any further.
Yeah.
But the employer says, no, you've been fighting at work, this is a serious issue. We in order to give a clear message to other employees how these things affect the workplace, we need to be seen to be taking action. And
also to be seen to be acting consistently.
Yeah.
So the last thing we want is to say, oh, in that case, you just blinked on the harassment.
Yeah.
And then if there are going to be forms of harassment which are serious and an informal procedure is completely inappropriate, and you're going to need a formal procedure, the code mentions disciplinary hearings, and also because harassment is going to be most often framed as unfair discrimination, it might need a CCMA referral.
Yeah. All right, so there are four clear areas where we think employers need to have action plans, and we hope that's given you some food for thought under each of those areas. As I've said, this is merely up on the screen a summary of the points, and the paper that will be available up on Worklaw within the next few days will have this in much more detail. Let's talk about, no, I'm going to now stop sharing and we're going to move on. Okay, some problem areas in applying this code, Adam.
There's nothing in the code that you can disagree with, but
it might say the same thing on a number of it might.
It needs to
repeat itself.
The code
is too long.
It took me an hour and a half to read it, but it needs serious editing. But the code doesn't give enough emphasis to the fact that in a workplace, managers and supervisors are involved in every day monitoring of performance and dealing with incapacity and dealing with misconduct. And in those processes, which are usually awkward, they are likely to behave in a way which could be interpreted as harassment. Who wants to be rebuked for messing up the work again? You know, you could understand a manager saying, for goodness sake, how many times do I need to tell you? That comment, it possibly does fall into some of the examples of harassment. But this is a legitimate function of management to monitor performance, monitor discipline. And there are just too many overlaps where what I think is a purely normal and expected management functions overlap too easily.
So maybe there should have been a couple of paragraphs to balance those rights.
The example that I saw that I particularly saw concern. We know that an employer is entitled to deal with incapacity and disability. There's a whole code where if an employer can't make reasonable accommodation, is entitled to terminate the employment relationship with a person with a disability. And we understand that is a normal function, and it's sad that it happens, but it might need to happen. But the code includes the definition of harassment: intolerance of psychological, medical, disability, or personal circumstances. Now, how you see the overlap with that idea of harassment and dealing with a problem that deals with incapacity and disability. So I think it's too easy for a decision taken to terminate an employment can be seen as an act of harassment.
I think a further area that is of concern is that issues that might constitute harassment under the code also become a separate dispute under the Labour Relations Act. The code talks about demotion without justification. That's an unfair labour practice. It talks about the use of disciplinary sanctions without objective cause. well, that's an unfair dismissal. So the application of the code is probably likely to lead to more than one dispute, potentially arising out of the same cause of action, out of the same facts. I mean, this is really not something completely new. I mean, there's for example, a 2015 Labour Appeal Court judgment in ARB Electrical Wholesalers versus Hibbett, where it said there's no bar to an employee arising out of the same facts claiming both unfair discrimination and unfair dismissal, and claiming compensation in both cases. But the court did helpfully go on to say that any compensation awarded in the one would have to be taken into account in the other. So the employer would not be penalized twice for the same offense. But yeah, it's unfortunate that I think disputes, more than one dispute may arise out of the same issues.
Yeah, linked to that, Bruce, it's invariably harassment dispute or grievance is going to be described as unfair discrimination. Yes. That's its legal cubbyhole, as it were.
Yeah.
And we know that there are limitations on bringing in the CCMA arbitrating unfair discrimination. It can happen certainly if the person earns below a certain level, whether it's sexual harassment or the parties agree. Mm-hmm. But in other cases of harassment, the CCMA cannot arbitrate. It must that acts of jurisdiction, and it has to go to the Labour Court, which has got cost implications.
Yeah. And I think a fourth concern we mentioned previously in this presentation, but our fourth concern, I think it's a big concern, is that the description of harassment under the code requires it linking to those grounds under Section 6(1) of the Employment Equity Act. And there are going to be other arbitrary forms of harassment then, as there are arbitrary forms of unfair discrimination, where the employee who's being harassed or being discriminated against is forced to almost peg the harassment or the discrimination to one of those grounds. And because they then can't prove that link, they will then fail potentially in their harassment case.
Correct.
And that's, I mean, so maybe the code ought to have gone broader to cover summa harassment in its broadest sense, without having to analyze the reason why it was taking place. Yeah. All right, legal reasons to comply with the code. We mentioned these from time to time, but let's get into more of the detail on this.
So I'm not questioning the good HR reasons to comply.
Yes.
It's just legal. So it all goes to Section 60 of the Employment Equity Act. And just in summary, when there's an act of harassment, it's got to be brought immediately to the attention of the employer, who's got to do two things: got to consult with all the parties, and then it says the employer must take the necessary steps to eliminate the alleged conduct. And the failure to take those necessary steps triggers in the employer's liability for compensation.
Under
Section 60.
Under Section
63. Now, this is a form of what lawyers call vicarious liability, which in the common law, an employer is liable for the wrongs done by an employee in the course and scope of business. This is more refined. But in Section 64, it says that an employer will not be liable if it can show that it's done all that was reasonably practicable to ensure that the employee would not act in contravention of the Act. Now, there are a couple of interpretations of the Section 60, whether it looks back to see what the employer has done in the past, or whether the employer has acted on that incident. Leave that aside, the courts have nevertheless have not been slow to award compensation, where they find flaws in what the employer has done. In the Checkers case I'm going to discuss in a moment.
Well, let's bring up, I have a PowerPoint. Let's bring up the two cases that, and there are obviously other cases, but there are two recent cases which we can have a look at.
Well, let's focus on these. In this first arbitration award, a compensation of 200,000 Rand was awarded. Now, that's a breathtaking amount of money for an employer who might have had a sexual harassment policy, who might have had good sexual work education on the stuff. But what the facts, of course, are going to determine it. In this case, involved a new employee, only been employed for 26 days. She gets invited by a very senior manager to meet her, an executive, in his hotel. And alcohol's involved. Here, this young woman who didn't want to put a foot wrong to jeopardize her new employment, she goes along with drinking. And when he wants to dance in the hotel room, she is reluctant, but does. But then she starts to panic. She realizes this is going somewhere where she didn't want it to go. And she has to find a way of disengaging in a way that doesn't destroy her chances. So those are the facts. And in this case, it was the very senior employee and a very new employee that was seen as being an aggravating factor. And one of the complicating factors is that this very senior executive, they really needed him to mentor. That he offered to resign because he knew he had crossed the line, but they wanted to stay on for 2 more months to hand over. And in those 2 months, the court, the arbitrators saw that it didn't protect this young employee from what had happened,
and didn't keep her in the loop on action that was taken.
Yeah. So it was a lot of money for. There was, apart from holding the woman close in the dance, there was no. It was, it was traumatic in that way for a young employee.
Now, I'm correct that that this was an arbitration. That the arbitration in this case, because this happened since the code was published, and the arbitrator really went through the code in a fine detail and assessed the employer's actions against the obligations under the code.
But when it came to assess compensation, the arbitrator did not justify why that amount was chosen.
There was no evidence laid to formulate.
Yeah, I drew out of the facts of the case the likely factors.
Yes.
In contrast, if we can go to the next case, this was a case before the code became operational. The initial compensation by the arbitrator was 50,000. In this case, the facts were that a manager was engaging with an administrative assistant and as a casual thing, slapped her bum and giggled.
Mm-hmm.
And she went to meet. She immediately was offended, and she went and reported to someone straight away. Checkers acted very promptly. They took it seriously. The manager denied that he did this, and he was sent for polygraph testing. Because the grievance was framed in the words that he slapped me on a private parts. That was the question put in the polygraph test. Did you slap the woman on her private parts? He obviously didn't regard slapping on a bum as a private part. And so the polygraph report was that his credibility was not affected. They then strangely swung it around, and they then turned the heat on the woman, saying, "We think you manufactured this evidence." And because there was no video evidence, no witnesses in this case. And they sent her for polygraph tests, and very strangely, it comes back that she came across as lacking credibility. And then they said, well, we're going to suspend you because we think you made up evidence against the manager. So that's the background. You can see it was messy.
Which led to a constructive, or she resigned, didn't she?
She resigned as
constructive
then they decided to charge her for false evidence and also for going off work without permission. She resigned, said it was constructive dismissal. So the arbitrator said 50,000 rand, but the difference was at the Labour Court, the judge carefully went through the circumstances which justified dropping it to 25 and said this was a single incident. The woman would have accepted an apology, she said, so it wasn't seen as by herself as being very serious. Checkers responded speedily, although there was some time lags, which the judge pointed out. And he looked at previous cases and he said in comparison with other more serious cases, 25,000 was an appropriate compensation. So I do think if the arbitration, the first arbitration there was taken on review, I think a judge might well want evidence of why it's headed to 200,000.
Yeah. Look, I mean, you referred to it just now, and we don't want to go into too much detail about it, but if you look at the strict wording of Section 60, there's an argument that says you look at the extent to which the employer ought to have done more to prevent the harassment, either by virtue of what it did before the harassment took place, or further acts of harassment after the initial act of harassment has occurred. And yet these cases seem to look more broadly at an employer's compliance with the code. For example, in the one, I can't remember which case it was between these two, but in the one case, the employer's failure to provide counseling and pay for counseling was taken into account in deciding on the amount of compensation.
Yeah, and also sexual Shockrock checkers didn't have a sexual harassment code. That was taken into account.
Well, maybe that's appropriate, because had they had a code, the harassment may not have occurred in the first place.
Yeah.
But the offering of counseling, as important as that may be, that has nothing to do to prevent future harassment. The fact that this employee who's now being harassed is having to be counseled.
Yeah.
And so, I mean, one can look at these issues with a fine tooth comb and say, should all of them be taken into account in the Section 60? But it seems as if the cases so far have been taking these issues into account.
Yeah. So, Bruce, for me, what this says is that there's a risk assessment, as Bruce said right at the beginning, there's a risk assessment reason why employers must get a policy in place, must do their education and comply with the code. That's, and it's a sensible form of management to put in place those things that will reduce any compensation that might be claimed.
Yeah. All right. Well, we're about to move on to our next section, dealing with evidence. But we hope you found that helpful, useful. We try to be as practical as possible, looking at what you've got to do to implement this new code, and we've tried to alert you to some of the problem areas that you may face. So the code is up on Worklaw, and our notes will be available in the next few days as well, and we hope that you find that helpful. Okay, let's change tack completely. Second part of this workshop, compiling effective evidence to support disciplinary charges. Well, you can ask what we mean by rules of evidence, and they really those rules and principles that govern how you prove facts before a tribunal, be it an internal inquiry, be it an arbitration, be it a court, and so on. And you might ask yourself, well, do you need to apply the rules of evidence at your internal inquiries, given that the Code of Good Practice talks about, and item 4.1 of the dismissal code talks about an employer conducting an investigation to determine whether there are grounds for dismissal. That this does not need to be a formal inquiry. So let's ask you, what do you think? So I'm going to call up a poll, and I must tell you, we got this idea from Tanya Fenter of Takiso, which, as you know, is probably the best dispute agency in the country. And I've launched a poll here, and I'm asking you what you think. Is a chairperson legally required to apply basic rules of evidence at internal inquiries? Please vote, express your view. Your individual views will not be known to us or to anyone else. If there are 100 of you out there and 50 people vote yes, the score will be 50%. If 50% of you vote no, that score will be 50%. All your scores will be aggregated. So I see that I'm giving you another 5 seconds. 5, 4, 3, 2, 1. Let's end the poll. Let's share the results. And it says, it seems to say that
79%.
79% of you say yes, that you do think that a chairperson is legally required to apply the rules of evidence at your internal inquiries. Interesting. Well, we think probably that legally there's no legal obligation to do so, but we agree with the majority that it's a really good idea to do so. And there are two reasons why we say that. Firstly, by applying basic rules of evidence, which we're going to outline to you, and we're going to simplify them to a substantial extent, but by applying basic rules of evidence, we think gives you the best chance of arriving at the truth. And that's your job as a chairperson of an internal inquiry, to arrive at the truth of the matter as best you can. So applying these basic rules of evidence, which we're going to take you through, we think gives you the best chance of doing that. Secondly, if your case then gets taken to the CCMA or the arbitration at your bargaining council, the arbitrator at that level is most likely to apply these rules of evidence. And if your case is not going to stand up to scrutiny there, and if you're going to lose the case there, we'll know that up front. Why take a case on when it's not going to stand up to scrutiny at the CCMA or at your bargaining council? So we think it's a good idea, and we're agreeing with you, with the majority of you. Let me call up a PowerPoint here, which I want to share with you. Rules of evidence. We're summarizing the rules of evidence, and obviously it is quite a complex area, but we're summarizing it into two broad principles. Is the evidence admissible? In other words, can you use it? Is it allowed in? If it is, what is persuasive evidence? What's going to persuade you that one or other version is the truth? And we can really summarize all the general rules of evidence, which we're going to speak about, under these two hurdles or headings. And if I had a flip chart, I would draw a picture of a person's head, of their skull.
Very badly, probably.
Probably very badly. Art is not one of my strong points. I have many others. The first point, admissibility, is all about what do you allow in, or what do you bounce off and not even taken into account? And then secondly, what is admitted, what has been allowed to enter your brain, your skull, that you apply your mind to, what is in there that's going to persuade you as to one version or the other is the better version that you ought to accept? Alan, talk to us about some problems with admissibility, some of the usual concerns.
Yeah. Also, I think the one that comes to my mind most of all is hearsay evidence. And this is a legal term to describe evidence where the person who saw something or did something isn't available, but a person who was told about it is available. It's evidence at one step back, as it were. And because of that very nature, it's unreliable, because the person who saw something or did something isn't available.
So it's evidence that you cannot cross-examine on.
Correct. And it's not only refers to a person, it refers to a document, because a document is a form of hearsay evidence because you can't cross-examine a document.
Yes.
So
now the 1988 Law of Evidence Amendment Act gives a presiding officer a discretion to allow hearsay evidence in specified circumstances.
Yeah.
Such as when it's in the interest of justice to do so.
And you find that the CCMA has had many awards where they have required this test is in the public interest, and also they ask why can't the person who is the main witness, why can't they be here before they will allow in hearsay evidence?
Should we ask our audience our next question?
Correct. Let's ask them.
Let's ask you about affidavits. What do you think? Oops. Give me a sec. A manager is in the building, but says he's too busy to attend your hearing. He provides you with an affidavit as evidence. Should the chairperson allow this evidence to be used? All right, give us your views. Counting down, 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. No. So 87% of you are saying no.
Well, I think that's right, because and should take that thing down.
Stop sharing.
I think the decision maker, the disciplinary chair, is under an obligation to use the best evidence. If the best evidence is walking around the factory and can be called in a moment's notice, that's the best evidence.
So if you're the chairperson of that inquiry, you should adjourn the inquiry and say, let's allow, if he's too busy at the moment, let's reconvene tomorrow morning when he's available.
Look, an affidavit would be acceptable if a person has left outside the country, or maybe has died, or just can't be contacted. There are circumstances where the affidavit would be the best evidence.
So it might be admissible, but how do you then deal with it at the next level?
You've got to say to the parties that it will have a low level of credibility.
Yeah.
Because it can't cross-examine an affidavit.
So it might be outweighed by oral direct evidence led by a witness.
Correct.
That's
right. I wanted to talk quickly about one form of documentary evidence, which is usually admitted. Doctor certificates are a form of hearsay evidence, but because of the expense of getting doctors to come and testify at disciplinary hearings, it's generally accepted that what the doctor certificate says is going to be given some kind of weight.
Yeah. Do you want to talk about similar fact evidence?
Yeah, there's another question.
All right. I hope you're enjoying these polls.
Bruce is very excited about them. So the question is, can the facts,
hang on a second,
can the fact that the employee committed a similar offence before be used to prove that he or she has now done it again?
What do you think? 5 seconds. 5, 4, 3, 2, 1. This is your last chance.
Okay, look at it. The results are quite evenly balanced, 42%, 58%. Let me take that down. It's called similar fact evidence, and it is the legal principle is the fact that someone has done it before is not proof that a person has done it again, and so that's generally not admitted.
The fact that someone was drunk last week does not mean they drank now.
Yeah, but there's a difference. If a person has got a discipline record, that can be taken into account in the sanction.
In sanction, but not in proving the commission.
Not in proving that they did it today.
Yeah.
Okay.
All right. So that evidence would be inadmissible.
Yeah.
In the sense of attempting to prove that the person is guilty of the alleged breach or offence.
Yeah. I think you do see a lot of similar fact evidence on TV, American TV shows.
Yeah. Okay. All right. I said there were 2 hurdles. Firstly, is it admissible? We've given you some examples of evidence that might be inadmissible or admissible. So let's now focus on the evidence that's been included, that's admissible, and what would persuade you that one or other version is the correct version. Don't forget, when a witness is giving evidence, that the person might be telling the truth, they might be lying. Thirdly, they might be telling the truth but making a mistake. They might have an honest view, which they're telling the truth about what they think happened, but it might not be the correct version. I mean, there's Alan and I talked about an example where there was a case of 2 lawyers, and that might explain what I'm going to say, but there were 2 lawyers in the car and they were traveling together, and this serious car crash happened in front of them. And they helped the witnesses. There was a person who passed away in the crash, and they helped sort things out. And afterwards, they realized that they would be called as witnesses about this crash. And they couldn't agree between themselves which direction this one car had come from. And so they were both giving honest evidence, but their versions were not the same. Clearly, one of them was giving a mistaken view of what had happened. And you're going to find that is often the case in your inquiries, where someone may be telling the truth, but they may not have a correct recall of the events in question. Now, your job in arbitrations, your job if you present a case at an internal inquiry, is to get your witnesses to tell the truth You can't put words in their mouth. You can't coach them on a false version, but in the version they believe in, get them to tell the truth in the most persuasive way they can. It's a fact that some people tell the truth badly, others lie extremely well, but your job is to try and coach your witnesses, if that's the right word. Coaching, you might not like that word, but to get your witnesses to tell the truth in the most persuasive way they can. If your witness is saying, you know, I'm not sure, but I think what happened was X, Y, Z, well, that's not going to make an impact on the judge or the arbitrator or the chairperson. Get the witness to look the person in the eye, and if they don't know something, say, I don't know that, but what I do know is X, Y, Z. So a person's behavior in the manner in which they give their evidence becomes important in how much weight or strength is likely to be given to that evidence. Also, if you are leading your witness, think about the style of your questioning. If you're asking leading questions, the answers to those questions are probably going to have less of an impact than if you asked an open question. If I asked Ellen in the case, you know, is it correct that when this happened to you, that you felt outraged, that you were upset, that you felt insulted? And he looks at you and he says, yes. Compare the impact of that with if I said to Ellen, how did you feel when this happened? And he said, I was traumatized. He was traumatized. You can see how traumatized he is and how impactful his evidence is if he could have done a better job. All right. Look at motive. Look at the independence of a witness. Why would this witness lie? Why would he or she make up these events which they are telling the court about or the arbitrator about? Alternatively, has the other witness, do they have a motive? Is there a reason why they would put this forward? So an independent witness becomes a very valuable witness. Look for other facts that can substantiate and back up the points that you're making. So 2 + 2 = 4.
Bruce, what I think you're saying is that arbitrations, and it applies to disciplinary hearings as well, arbitrations are won and lost on the evidence presented.
Yeah, and there's no, and the cases when they talk about this say there's no magic formula that you can apply to assess credibility, but you look at a basket of factors that we've been talking about now.
Yeah. So
that leads us onto a balance of probabilities of the test. What is the most likely probable version of events? Ellen, do you want to talk about the onus and the different legal tests which are applied in different circumstances?
Well, I think you're referring to that in criminal courts, it's proof beyond reasonable doubt, whereas in the workplace, it's on a balance of probabilities. And that's sometimes hard to explain, but you know, it really is a balancing of what's more likely, what has the ring of truth about it. It's a balancing of the evidence and coming to the conclusion. But I think there's a question a poll question we should ask.
All right, is there? Have I missed out one?
Yes.
Okay, let's ask you a question.
So it says, if you as chairperson, after hearing all the evidence, are still uncertain whether the employee committed the offence, can you impose a lesser sanction than you would otherwise have done? For example, a final warning rather than dismissal.
All right. Answers, please. You judged on this, by the way. We scoring you. No, we're not. Okay, 5 seconds. 5, 4, 3, 2, 1. Share the results. There we are. 69% of you say no.
It's a difficult area. I think I certainly agree with the 69% that that if a person, on the balance of probabilities, a person is not found guilty of misconduct, that person walks free. And
absolutely. So
unless the charges were phrased with a lesser charge.
Yeah.
So you could be that the person stole or was dishonest. And if there's no evidence that actually was stealing, but there is evidence of dishonesty, you could give the final warning there.
for a lesser charge.
Lesser charge.
But I think the principle that we're trying to enforce here, in the same way that those two evidence hurdles were separate independent hurdles: admissibility, what evidence is allowed to be used, and secondly, based on what evidence that you're allowed to be used, how much weight do you attach to different versions? Those are two separate independent hurdles. Yeah, what I think the point that we're trying to make is that deciding on guilt or breach of a company rule is the first hurdle. Do you think there's enough evidence on the balance of probabilities to substantiate that there has been a breach? Only if there is, do you then go on to look at what is the appropriate sanction or penalty. You can't reduce the penalty because of your uncertainty about the guilt. They are two separate independent hurdles. I think that's the point we're trying to convey to you. Yeah. All right. Talk about the onus, Alan, just if there's anything more on the onus.
I don't think I would do more.
Okay, all right. So if there isn't enough evidence on a balance of probabilities, then because the employer has the burden of proof, the duty to prove its case, the benefit of the doubt is then given to you.
Maybe I can just add that there have been a number of cases that say that disciplinary charges framed like criminal charges should be avoided, and you should charge a person, you're charged with misconduct in that, and it's a very simple description, but the main charge is of misconduct, a general concept, to avoid the employer not being able to prove one little element of a very complicated factual charge, that on this day you did this and said that, to avoid that, because the Labour Court seems to be encouraging a looser framing of charges as long as the employer understands what's been charged.
I think you're going on a bit.
Okay, right, move on.
All right. Let's take the rules of evidence that we've been talking about, and I want to apply the principles that we've been talking about to item 7 in the unfair dismissal code. This is basic stuff, but it's important stuff. There's a framework given to you in the unfair dismissal code. Was there a breach of a company rule? Is the rule valid or reasonable? Was the employee aware of the rule? Was the rule consistently applied? And was dismissal the appropriate sanction? You need to be able to lead evidence. If you're preparing for a case of arbitration or even an internal inquiry, if any or all of these issues are disputed, you need to be able to formulate and have evidence to prove your case under each of these points. And it's a really, I can't stress this enough. It's a really useful framework for you in preparing a case to prepare your evidence under these headings, so that if necessary, if all of these issues are in dispute, you're able to prove your case on each issue. If an issue is not in dispute, just don't forget that admissions are a form of evidence. If it's admitted, then you can ignore it. But in preparing your case, be prepared, if necessary, to prove your case on every one of these aspects. Equally, if you're the chairperson of an inquiry, this is a really useful framework to use to write the outcome of your case. And you can highlight what's admitted, what's in dispute, and then focus in on those 5 points. What are the key areas which you need to then weigh up the evidence from both sides and decide on a dispute of fact as to which version that you accept. Equally, arbitrators use this framework as well. You will see this coming through in CCMA arbitrators, this kind of framework that they write their awards under. So it's a really, really useful framework. Alan, give us...
well, I'll speak about the first one.
Is there a breach of a company rule?
Notice there's 2 aspects to this. There's the company rule, and there's the breach of that rule. So
you might have to prove the existence of the company rule, and that there's a breach.
Generally speaking, the existence of the company rule is not disputed, but there could be there could be some practice that's developed, and the employee says, I didn't know about any rule like that. In fact, often there are occasions where employees will say, I didn't know there was a rule. But I just want to stress.
Well, let's ask our next question. Is there a rule, for example, two employees fighting outside the workplace? If there's merely under the company's code, assault is mentioned and there's a sanction for assault, but there are two employees fighting outside of work, off company premises, is that a breach of that rule? Let's ask our
Delegates,
our audience what you think.
can you discipline an employee for conduct outside the workplace and off company premises?
5 seconds. 5, 4, 3, 2, 1.
Okay, so you've got a huge majority here who's saying yes, you can.
89%.
And generally speaking, can you take that thing off?
Oops.
Yeah.
Sorry.
Generally speaking, the employer only has jurisdiction of that things happened in the workplace. But as the majority saw, that if the assault outside the gates of the company impacts on what happens inside the company, then the employer does have jurisdiction to discipline. But there has to be a connection between what happens outside and what happens inside.
Yeah.
And so, for example, if an employee is charged criminally for beating a neighbor at home, I know some employers will say, oh, it's impacting on bringing the employer into disrepute, but I don't know whether you can say something that happens on the weekend necessarily can be.
Well, it would have to prove its impact
Yeah.
on the working relationship.
Yeah, just kind of say that one of the most common forms of challenge at the moment on this is where people use social media to be critical of a manager or the employer. And their fix is, this happened in my private time.
Yeah, and what's been the outcome in the most of those cases?
So in most cases, the arbitrator will say, no, it has an impact in the workplace.
Yeah. Just other areas where there are problems about proving the breach of a company rule. I mean, I can refer you to quite an important Labour Appeal Court judgment that we dealt with in our April newsflash this year, the case of Austin Day versus Absa Bank. And here was the facts of this case are interesting. This was a bank manager, a senior person in the bank, who was opening bank accounts in the names of the bank's customers in order to improve her score rating. There was some score rating of managers based on how many accounts had been opened, and she was opening herself bank accounts in the name of her customers without their knowledge or consent. And she was charged with a lack of honesty. And she was dismissed, and the case went all the way to the Labour Appeal Court. And the employer could not prove the lack of honesty. She'd certainly breached company policies and had acted in a very inappropriate manner for a bank manager, but she'd been completely honest in doing this. She'd done it openly. She told other bank people about it. She was doing, and she told the reasons why. So there was no lack of honesty at all. So in fact, there was the breach that she had been charged for had not been proved, and her dismissal was found to be unfair on that basis. Other areas where there are problems, and I think there are going to be problems going forward, testing positive for DACA or cannabis. This is a problem area, I think. The health and safety legislation talks about being under the influence. Alan will tell you from his own experiences that cannabis can stay in your system for a lengthy period of time if you're a regular user of cannabis. It can stay in your system for up to 6 weeks.
Bruce, I feel you're harassing me.
No, but the point is that cannabis does stay in your system for a long period of time, if you're a regular user of cannabis, and I'm told it can be for up to 6 weeks, and you can come to work completely in control of your senses. You're not under the influence of cannabis at all, or of any intoxicating substance, and yet you can test positive. The recent Labour Court judgment in Eneva versus Barlow World, which we spoke about a couple of months ago in one of our newsletters, they seem to mix up the notion of testing positive and being under the influence. The judgment did speak about the need for a scientifically validated test to test levels of impairment. So it highlighted the distinction between testing positive and whether or not you're under the influence. But it still seemed to conflate the two in its outcome, and effectively confirmed the dismissal of a person for having tested positive when there seemed to have been some doubt whether they were under the influence or not.
But Bruce, if there was a workplace rule which says you may not test positive for cannabis, is that
Well, that brings us on to our next question in that framework, which I've shared with you just now. Is there a rule? Is the rule reasonable? And you can see how potentially an employee could challenge the reasonableness of a rule in these circumstances, potentially.
I think it's I think it is an unreasonable rule to under those circumstances. Intoxication, we understand.
Yeah.
Being under the influence of drugs, we understand because of the impact on work. But because using dacha now is regarded as legal in the home context, it is, I think,
it's questionable whether the rule of testing positive might be a reasonable rule.
Yeah. The other case on the question of is the rule reasonable, there was a case where there was a workplace rule that an employer could not wear a T-shirt which had political colours and slogans. And I think it was really aimed at red T-shirts, and it was trying to stop inter-political party fighting. And the question was whether or not it was a reasonable rule to limit a person's freedom of expression through wearing a T-shirt.
Yeah.
The case said it wasn't reasonable to have that rule.
Okay, let's just go back to that framework. Alan, won't you talk us through the third rule and what evidence you might perhaps call upon to prove that the employee was aware of the rule?
Well, actually, item 7 of the code talks about whether the employee was aware of the rule or could reasonably be expected to be aware. So it's two aspects. Often now this is not challenged, but if it is, you might, the kind of evidence you might need is, for example, the fact that the employee signed an employment contract which incorporated various rules. That might be some evidence, but I'm not too sure all the employees read the attachments to the employment contracts. And so you'd have to perhaps show that there was evidence on notice boards about rules and knowledge of discipline about those rules in the past.
Or that it was dealt with during the employee's induction program.
Yeah. What's more complex is where there's some credibility the person didn't have knowledge of the rule, but the argument is he should reasonably be expected to have been aware.
Or ought to be aware.
Ought to be aware. And there's a recent case, Volkswagen versus Nomsa, where the facts are complicated, where an employee arranges for her boyfriend to participate in the hijacking of a company car because to cover up the fact that it had been repaired outside of procedures. And so you think there's this disciplinary rule about you mustn't arrange hijacking. Of course there isn't, but you ought to know that you can't be arranging the hijacking of company cars.
So any of you out there thinking of doing a hijacking today, not a good idea.
Yeah.
Okay. The next point that we raised, and I'll call it up again because I think it's useful just to highlight it again, was the rule consistently applied? And there's a recent Labour Appeal Court judgment which we dealt with in our August newsletter, which looked at historical consistency. So how have you dealt with cases in the past, and also contemporaneous consistency, dealing with all employees who committed the same offence in the same way. And it's quite a useful judgment. It highlights the difference between these two. And you would need to lead evidence on this, that you could lead evidence about past cases, and that all employees in this instance were treated the same. But the case did highlight that there may well be circumstances which justifies different treatment. Different employees may be on different levels of warnings, maybe on a final warning, the other may be having never been warned previously. So there may be reasons why different approaches are taken, and each case still has to be viewed on its merits.
Bruce, there's even one case which says an employer can't be held hostage to a bad decision by a previous chairperson.
Yeah. All right, Alan, talk us through the last point, dismissal. Is it always necessary to lead evidence that dismissal is the appropriate sanction?
Well, I think that's, I think generally speaking, there's needs to be some kind of justification for the ultimate sanction of dismissal. I don't think that the employer, once you have established a balance of probability the person is guilty of the conduct, I think then it's the role of the chairperson to find the appropriate sanction.
But do you need to call a witness who says, I can't work with this person any longer? The employment relationship between us is broken down. Well, I can't trust this person anymore. Is that always necessary?
There have been a number of recent decisions, which are in our notes that you will receive, which is that if the matter it's a really grave matter, very serious matter, there's no need. It's obvious the relationship is broken down. You don't have to then need evidence.
Based on the facts of a case.
But in specific circumstances, even on a minor incident like repeated late coming, where the person's been warned and warned and warned, you might have to explain that actually the relationship is broken down because you can't trust the person to come and join the shift, and they play a pivotal part in the shift. You know, so I would say that you should always consider calling someone, a manager, to say, look, the relationship's broken down. But in cases of serious misconduct, the cases have said it's not necessary.
It speaks for itself based on the facts. And there are a couple of judgments there which you'll see in our notes. There's a Labour Appeal Court judgment and some other judgments as well, which confirm it. Let's talk about expired warnings.
So the general principle is that when a person has been sanctioned and had a warning, and there's a period of which it's valid and that's expired, the general principle is that it shouldn't be referred to again. But there are two cases which say that there are.
Hang on, let's ask. Let's ask our audience.
Right, sorry, I've got.
What do you think?
Okay, ignore what I've said. Just ignore what I've said.
Are you ever allowed to take expired warnings into account? Ever? In other words, are there some circumstances where you may be allowed to take expired warnings into account? What do you think? Everyone's on the ball, I think. 88% of you said that there are circumstances where you may be able to take expired warnings into account.
Let me say that the general principle is that you should, if a person's served their sentence, they shouldn't be harassed anymore. But there are two cases which say there are circumstances when you can take into account previous expired warnings. One is where the person was guilty of repeated misconducts just outside the expiry period. So they calculated carefully when they can next do something wrong. That's the one circumstance. The other one is where the track record shows what they called a consistently deplorable employment record. There comes a point where, yes, you might have, the warning might be expired, but if you take the person's track record into account, it just speaks for itself.
Yeah. Look, I mean, I think in both these cases, I think it's always subject to what your internal policies and procedures say. There's a company that we came across the other day that said expired warnings can never be taken into account. and the expired warning must be expunged. They use that word from the employee's file. Now, in that instance, it's very difficult to then depend on these cases and say that, well, there are exceptional circumstances, we should take expired warnings into account. So your internal procedures should say and specify the circumstances under which expired warnings can be taken into account, where there's a consistently deplorable employment record, as an example. And so it opens the door to being able to do so in appropriate circumstances. Well, whilst we're on this, can I also cover a particular hobby horse of ours, is that warnings are normally for particular types of offences, timekeeping offences, attitudinal offences, and generally a warning for one type of offence doesn't apply for a different type of offence. I think you need to think about, because under appropriate circumstances where you've had an employee who's 1 month coming late, next month he or she is rude to a customer, next month they break plant and equipment, next month the person's under the influence of alcohol. There are a whole range of offences where it would be fair and you would entitle the employer to say, listen, there's a problem here, and you would be given a comprehensive final warning. Call it what you like. We like the term comprehensive final warning, applicable to any type of offence, which would then be taken into account if there are any further transgressions of the company's rules. All right. We've been going for quite a long time. That really covers the content of what we wanted to get through. Let's see if we hope you found this worthwhile. Let's see if there are any questions that you've asked us. The first question says, Bruce, you are mute. I hope that was a comment addressed to me before we began the workshop when I was mute. I hope
not sure
the person didn't find me mute throughout the workshop. The next question was, when does it become unwanted when we are used to doing it? It has been a practice.
Yeah.
Do you want to talk about that, Alan?
Yeah, I think this is a really complex, issue. I know there was an old case on sexual harassment when there was a boss who couldn't stop touching them, and he said he came from the Mediterranean, and in the Mediterranean it was a custom to appreciate women, and that was how men did. They appreciated women and they touched them. And the court said, I'm sorry, you might be Mediterranean background, but this doesn't justify you keep on harassing women. It's an old case before, it was actually about the early 90s. But I think it's a question. I don't know if you've got anything to say.
I mean, I think that, times change. And I know there was one case from some time ago where it was a really rough and tough environment. And there was a lot of swearing in the environment. I mean, there's a form of companionship or friendship on the way people spoke to them, but they would harangue each other and shout at each other and swear at each other. And I mean, that was that particular environment. But if you've got an environment where something's happened in the past and going forward, it should be unwanted. It's like introducing or reinforcing a rule, introducing a new rule where it should be told to employees, there should be something written in a policy to say, whilst this may be accepted in the past, going forward, these are the ground rules which are going to apply. So you make it clear what the standard is going forward.
Yeah, and there comes a point, I think, in the employment relationship where your own personal style and preferences have got to be sublimated for a community cohesion.
Yeah.
So, there might be somebody who really swears very, very strongly. And that's okay in their private life, but in the office, it's a cause of offence.
Yeah.
And the person must realize it's not wanted.
Yeah. All right. Other questions? What is an independent witness? Or just very briefly, it's a legal term, it's legal jargon. An independent witness is really someone who has no motive and no interest in the issues they're giving evidence about. They are They are independent of the issues which are being dealt with in the case. So it's a legal jargon, it's legal term, but that's the meaning behind it. So this person could be a co-employee, it could be a manager, it could be someone from outside the workplace, but they are independent of the issues which are being determined in that particular matter, and they don't have a motive or a reason to be giving their version.
I think that expert witnesses might appear to fit into this category of independence, but it's now, maybe I'm under the influence of American TV, but expert witnesses are interrogated. How many times have you given evidence in a court? And how many times have you given a ruling in favor of the manufacturer and so on? So
and also they're being paid.
They're
being paid to give evidence by the side that's called them as a so-called expert
and
witness.
So maybe a question to a witness who seems to be independent is, are you being paid to be here today?
And have you ever been paid to give evidence, an alternative view to the view that you're giving at the moment?
Yeah, but generally speaking, it's somebody who's a neutral witness who's got no interest in the outcome.
Okay. Is competent judgment allowed in disciplinary cases? For example, finding an employee guilty of unauthorized possession when charged with theft. Okay. If you want me to answer that, sure. Go back to basics, the basic adi alteram partem principle. Has the person have a right to have their say in respect of the allegations against him? So if there is a charge which involves, in a sense, a lesser charge, and the employees had their say, had their chance to express themselves, call witnesses and so on issues affecting the lesser charge, then maybe it would be appropriate for the chairperson to say, well, whilst theft hasn't been proved, it's clear that you were guilty of unauthorized possession. And so it would be appropriate and fair under those circumstances for the chairperson to perhaps find the person guilty of a lesser charge. But if the person has been charged with being under the influence of alcohol, and the chairperson wants to find the person guilty of coming to work late, when that was never the issue and never the facts of the case that were put before them, clearly you can't do that. And if there was an alternative alleged offence, that would have to be the subject of a separate inquiry, perhaps, when that charge is put. I find it difficult conflating the issue of consultation, which is a function of the affirmative action process, and unfair discrimination, which is dealt with separately under the Employment Equity Act. Do you want to try and answer that, Alan? I'm not sure really what the question is trying to get at.
I think that's maybe this is. Can I argue with Bash? You want to take
please.
The question down?
Yeah.
I think that's. I think this is what's being asked. That Section 60 requires the employer to consult as soon as there has been a report of harassment.
Okay.
So is there that kind of consultation at that point? And I don't think that's consultation in the sense of any kind of negotiation.
Okay. Okay. Yeah.
But I'm just guessing at the question, and maybe there's still time for you to ask something more specific.
Yeah. So consultation in that instance would be get in touch with the parties, find out what their points of view are.
I don't think you're consulting. It's not an investigation of facts. Well, it is, I suppose, because the employer needs to find out if there has been an act of harassment, and so there is a bit of fact finding. So it's consultative in the sense of trying to get to what the true story is.
Yeah. Okay. All right. I'm not sure if we can take that point any further at this point. If we haven't answered your question, feel free to ask it in a different form. Tell us the next question. Tell us the example of abuse of the disciplinary proceedings. Does it pertain to the timing, especially where the employee may have started a grievance process? I suppose it's just really a question of unfairly issuing an employee with harassing an employee with final warnings, written warnings, suspension, etc., when these are not warranted by the circumstances of the case. I mean, I think that's what it's talking about, which, as we pointed out, it then is a form of unfair discrimination, but it's also potentially an unfair labor practice or an unfair termination of employment.
Yeah, I'm sure there are many cases where the employer wants to get rid of the employee, and so I think it would fit into that category where there's scratching around to find some evidence of some misconduct, and sometimes you see the charge sheets where there's like 10 different charges, all slight variations of the others, but it's to try and kind of impress upon the chairperson the person is beyond saving. But I think it's often there's a political agenda sometimes, and I think that's I think that's the abuse of the disciplinary procedure.
And then, as was asked in the question, I mean, those kind of examples often pertain to the person having lodged a grievance or some kind of whistleblowing or something along those lines.
Yeah, we're dealing with a case in our next newsletter where, in fact, there was a whistleblower, and pretty soon thereafter, the employer feels they need to restructure the organization. And guess what? She's chosen for retrenchment. Yes, that's kind of thing that can happen.
All right, we have got time. We have still got time. Section 16 requires consultation only on issues of affirmative action and nothing more. All right,
Section 16 of what?
It's the same. It's the same questionnaire from the previous one. Maybe we can come back to that. Can a single offence of unwarranted conduct constitute sexual harassment? Ellen, you can answer this. Can a single offence of unwanted conduct constitute sexual harassment?
That's an exact statement in the code. That a single incident can constitute. There was this famous Sinners case which went from the Labour Court to the Labour Appeal Court, and at the Labour Court, the judge. The man in question said to the woman, "Do you want a lover tonight?" And she said, "No, I've got a boyfriend." And she went to her hotel room. He went to his hotel room. And the judge of the Labour Court said, he asked a question and he stepped back straight away. And it was a single incident, and it didn't constitute harassment. When the Labour Appeal Court got hold of that, they said absolutely not. He should have known to even ask that question was an act of harassment.
I mean, in that case, there was a huge age gap between the two. It put the employee, who was a much younger employee, into very vulnerable.
But he wasn't an employee; she's an outside consultant.
She was an outside. I think she was an employee and he was an outside consultant, wasn't it?
No, because he got disciplined. So he's a
sorry, okay. He was the employee, she was an outside consultant. And they were working in Botswana on a project.
But look, I think I've got to say that 22% of people get married from relationships that start in the workplace. And it usually starts, would you like to come out for supper tonight? And so sometimes we go to.
I think maybe there's a slight difference between would you like to come out for supper tonight or do you want a lover tonight?
The point I'm making is that you can't avoid sexual chemistry in the workplace, and I think that's.
But I think there's a clear message that you have to tread on very dangerous ground. That you are treading on dangerous grounds, and you've got to be careful when you're pursuing a relationship that arises out of the workplace, that you don't cross a particular line.
There's huge dangers these days in having a workplace romance.
Well, that's not consensual.
Yeah, certainly.
Yeah, and the fact that and the cases have also been clear that the fact that there was consensual sex in the past does not mean that there's consensual sex going forward.
Correct. Yeah. So that's in the code.
Regarding clothing, T-shirts with party political colours or logos, if this rule is entrenched in a disciplinary code and repeated, during induction sections for new recruits, could the court still find that it is not a reasonable prohibition in the company's rules?
Yeah.
Maybe I can have a go at that. I mean, there's clearly then a rule, but don't forget a rule has to both exist and then it has to be reasonable. So potentially a new employee could challenge the reasonableness of that rule, and you would have to motivate the reasons why that rule which exists, why it is a reasonable rule, and why there are workplace needs that need to be fulfilled in implementing that rule. So I think it is possible to challenge the reasonableness of a rule, and its reasonableness would have to be determined on the facts of that case.
Yeah, I can imagine you could get a witness is to talk about how the rule was introduced in the first place, and the kind of, I could see very clearly the evidence saying it's the employer's obligation to keep all workers safe.
Mm.
And this was because of the inter-political party conflicts, rivalry. This was our step to keep our workers safe. I could see that evidence being persuasive in a court.
Yeah. All right, those appear to be all the questions that have been asked of us. I'm sorry that the one person who reframed that question, maybe it's our fault that we don't really understand the extent of your question in section 16 consultation. Perhaps you can drop me an email, bruce@worklaw.co.za, and we can come back to you on that issue if we haven't answered your question appropriately. Thank you, Ellen, for coming up. We've been going for an hour and a half, so we're going to call a halt to proceedings there. I think we've still got a large number of people present, so hopefully we've kept your interest and spoken some sense at some point in the last hour and a half. Thank you for your ongoing subscriptions to Worklaw. We hope you found our newsletters interesting. We've got a newsflash, for example, coming up next month. We will be talking about a recent judgment where the court literally interpreted the requirements of the Code of Good Practice on dismissal and said it's no longer necessary to hold a disciplinary inquiry. So I won't say any more of that. Wait and see what the newsflash says, but and whether we think that's is a good idea or not. But that'll be coming to you next month, and our October newsletter will be coming out in the next couple of weeks. So thank you, and hope you have a good day. Cheers.